Hello, privacy enthusiasts and curious minds. Welcome to our deep dive into the fascinating world of GDPR. Today, we're exploring two very specific, yet crucial, pieces of this privacy puzzle, Articles 10 and 11. Let's start with Article 10, Processing Criminal Data. This article lays down very strict rules for handling personal data related to criminal convictions, offenses, or security measures. The core text states that such processing should only be done under the control of an official authority, or when explicitly allowed by union or member state law. And crucially, that law must provide appropriate safeguards for people's rights and freedoms. Why such strictness? Well, data about criminal convictions is incredibly sensitive. Imagine the discrimination or injustice that could arise if this data was misused or fell into the wrong hands. That's why GDPR demands exceptional safeguards. So, for any organization, processing this kind of data is only allowed under two main conditions. Either it's done directly by an official authority, like the police or courts, or it's authorized by law, meaning there's a specific, clear law that permits it, and importantly, this law must include strong protections for the data subject. Imagine a private company wants to run a background check before hiring someone. If they check criminal records without legal permission or proper safeguards, that's a violation of Article 10. On the other hand, law enforcement or certain licensed bodies may be authorized to process this kind of data, but only within the limits of their lawful powers. Now, let's shift gears to Article 11, processing which does not require identification. This one's a bit different but equally important. It essentially says, if you, as a data controller, don't need to identify someone to achieve your purpose, then you shouldn't be forced to collect more information just to identify them for GDPR compliance. This article champions the principle of data minimization, a cornerstone of GDPR. It encourages organizations to only collect and process data that is absolutely necessary, adequate, and relevant for their specific purposes. Why? Because the less identifying data you hold, the lower the risk if there's a data breach. It means if you can achieve your objective using anonymized or pseudonymized data, and you don't need to know who the data belongs to, then GDPR doesn't oblige you to go out of your way to find out. You get an email from a company you've never heard of. You didn't sign up, but they somehow got your details. Turns out, they purchased your data from another company. That company must tell you where they got your data, why they're contacting you, and how you can opt out or object to the processing. That's Article 11 in action, giving you control, even when data is shared behind the scenes. So, to sum up these two fascinating articles, Article 10 tells us that processing data about criminal convictions is extremely sensitive and requires either direct official authority or specific, safeguarded legal authorization. Article 11 emphasizes data minimization, encouraging organizations to avoid identifying individuals if it's not necessary for their processing purpose. Both articles reinforce a core GDPR philosophy, respecting individual privacy by handling personal data with care, purpose, and proportionality. We hope this journey through Articles 10 and 11 has made these important GDPR concepts clearer for you. If you found this video helpful, please give it a thumbs up and subscribe to our channel for more insights into the world of data privacy. Let us know in the comments if there are other GDPR topics you'd like us to cover.